Attorney General Brian Frost and I are here today to announce that earlier this morning, the state of Maryland and the District of Columbia filed a lawsuit in federal court against the President of the United States. The suit alleges that President Trump is flagrantly violating the Constitution, which explicitly bars presidents from receiving gifts or inducements from foreign or domestic government entities.
Okay, so what I'm about to describe to you is one of the most extraordinary and alarming moments in modern American political history. And if you haven't seen the footage yet, you absolutely need to understand what happened and what it means for the future of our constitutional system. During a live public event, President Trump launched into a blistering attack on the U.S. Constitution itself, not just on specific rulings or individual judges, but on the fundamental concept that constitutional limits apply to presidential power. And in response, a Supreme Court justice did something that has essentially never happened before in American history. They stood up and walked out of the event in dramatic, unmistakable protest while cameras captured the entire thing. That footage went viral within minutes and has now been viewed by millions of people who are trying to process what it means when a sitting president claims the Constitution doesn't apply to him and a member of the nation's highest court responds by refusing to sit and listen. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
Now to Washington, where an overnight move by Chief Justice John Roberts allows a U.S. foreign aid package to stay frozen for now. Roberts paused a district court order for the Trump administration to pay up millions by midnight Wednesday. I want to bring in CBS News correspondent Natalie Brand, as you see there. She's live at the White House for us. Natalie, walk us through what we're hearing from the Supreme Court on this, how it reached its decision.
Good morning, Errol. And specifically what we're hearing from the Chief Justice, because it's Roberts who oversees requests for emergency relief from cases stemming from Washington, D.C. District Court. So that's why he made this decision last night, saying in this ruling that the administration did not need to immediately pay an estimated $2 billion in foreign assistance to pay for projects that had already been completed. Now, his ruling came after a federal judge here in Washington gave the State Department and USAID until midnight Wednesday.
Let me walk you through exactly what Trump said, because the specific words matter enormously here. According to the footage that's been circulating, Trump stated that the Constitution doesn't really apply to him when it comes to executive power, and that judicial review is essentially meaningless as a constraint on what a president can do. He characterized constitutional limits on presidential authority as optional rather than binding, suggesting that he views the entire framework of checks and balances that has governed American democracy for nearly 250 years as merely advisory guidelines that he can choose to follow or ignore based on his own judgment about what's necessary. Come on, think about what that actually means if a president believes it and acts on it. The Constitution is the foundational document that creates and limits government power in America. The entire system of checks and balances, Congress passing laws, the president executing them, the courts interpreting them, and ensuring they comply with constitutional requirements, depends on everyone accepting that the Constitution is supreme and binding. When a president says the Constitution doesn't apply to him, he's not just expressing a legal opinion, he's claiming the authority of a dictator who can do whatever he wants regardless of legal constraints. That's not normal political rhetoric or standard partisan disagreement. That's a direct assault on the foundations of American constitutional democracy. The justice who walked out, and the specific identity matters less than the symbolism of what happened, apparently reached a breaking point that many observers have been wondering about throughout Trump's confrontational relationship with the judiciary. Judges have been remarkably restrained in responding to Trump's attacks on courts, individual judges, and judicial independence generally. Chief Justice Roberts has occasionally issued statements defending judicial independence, including his rebuke of Trump's calls for impeaching judges who rule against him. But actually walking out of an event where the president is speaking represents an entirely different level of protest, a physical, visible rejection that communicates disgust and alarm in ways that written statements cannot. The video of the walkout apparently shows the justice rising, gathering their things, and leaving while Trump continues speaking, creating a moment of stunned silence among attendees, and a visual that immediately went viral. Within minutes, the footage was spreading across social media platforms, with commentary ranging from celebration to alarm, depending on political perspective. Legal experts began weighing in, with many characterizing Trump's statements as a direct threat to judicial independence and warning that normalizing such rhetoric creates conditions for genuine constitutional crisis. This isn't happening in isolation. It's happening in the context of ongoing legal battles between the Trump administration and the courts that we've been covering extensively. The Supreme Court is currently considering Trump v. Slaughter, a case that could determine the scope of presidential removal power and potentially overturn decades of precedent protecting independent agencies. Federal judges have been blocking administration actions on troop deployments, immigration enforcement, and various other matters. The administration has been found in contempt of court in some instances. There's an escalating pattern of conflict between the executive branch and the judiciary that Trump's constitutional comments dramatically intensify. The echoes of Chief Justice Roberts' earlier rebuke are significant. Back in March 2025, Roberts took the unusual step of publicly criticizing Trump's calls for impeaching judges who ruled against his administration. Roberts defended judicial independence and reminded the public that judges are supposed to apply the law without regard to political pressure or consequences. Trump responded by attacking Roberts personally and continuing his assault on judicial legitimacy. The walkout suggests that at least some members of the Supreme Court have concluded that Trump's attacks have escalated beyond what can be addressed through measured public statements. Legal analysts are warning that Trump's rhetoric, particularly the claim that the Constitution doesn't apply to him, could have direct consequences in ongoing and future litigation. When judges are evaluating whether the administration is acting in good faith, statements from the president claiming constitutional limits are optional become evidence of bad faith. Courts may be more skeptical of administration legal arguments when the president is publicly claiming that legal constraints don't really apply to him anyway. The rhetoric doesn't just offend constitutional sensibilities, it potentially undermines the administration's legal position across multiple pending cases. For Trump's approval rating, already at 36%, this footage adds another dramatic visual to the accumulating evidence of an administration in crisis and conflict with every institution meant to constrain executive power. The Epstein revelations, the Venezuela boat strike controversy, the health concerns, the Republican infighting, the Jack Smith subpoena, and now a Supreme Court justice walking out in protest of the president's attacks on the Constitution itself. Each crisis reinforces the others in creating an overwhelming impression of chaos, corruption, and contempt for the rule of law. So in this video, we're going to break down exactly what Trump said and why his claims about presidential power and constitutional limits are so alarming. We're going to look at the significance of a justice walking out and what it signals about the state of relations between the executive branch and the judiciary. We're going to examine how this connects to ongoing legal battles and what it might mean for pending cases. And we're going to discuss the implications for American democracy when a president claims the founding document doesn't apply to him. Stick around because this is as serious as political developments get. All right, let's get into the specific substance of what Trump said and why legal experts are treating it as a genuinely alarming departure from anything previous presidents have claimed about their relationship to constitutional constraints. Understanding the precise nature of his claims helps explain why a Supreme Court justice felt compelled to walk out and why this moment is being treated as a potential inflection point in the ongoing conflict between the administration and the judiciary. Trump's statements at the event went beyond his usual attacks on specific judges or rulings to challenge the fundamental concept of constitutional limits on presidential power. According to the footage, he claimed that the Constitution doesn't really apply to him when it comes to executive authority, a breathtaking assertion that essentially rejects the entire framework of limited government that defines American constitutional democracy. He characterized judicial review, the power of courts to evaluate whether executive actions comply with the Constitution and laws, as meaningless when it comes to restraining presidential power, and he described constitutional limits on what a president can do as optional guidelines rather than binding constraints. These aren't offhand comments or hyperbole that can be walked back as jokes or exaggeration. They represent a coherent, if alarming, theory of presidential power that legal scholars have been warning about since Trump first took office. The theory, sometimes called the unitary executive in its more moderate forms, holds that the president has essentially unlimited authority over the executive branch and potentially beyond. In its more extreme versions, which Trump's statements echo, it holds that no other branch of government can meaningfully constrain presidential action because the president embodies executive power in its totality. The constitutional problems with this view are fundamental and obvious to anyone who has studied American government. The Constitution explicitly grants Congress the power to make laws, control appropriations, and conduct oversight of the executive branch. It explicitly grants courts the power to decide cases and controversies, which has been understood since Marbury v. Madison in 1803 to include the power to review whether executive actions comply with the Constitution. The system of checks and balances that defines American government depends on each branch having the power to constrain the others. A president who claims constitutional limits don't apply to him is claiming powers the Constitution explicitly denies. The justice's walkout represents an extraordinary break with judicial norms of restraint and political neutrality. Judges, and especially Supreme Court justices, typically avoid any public conduct that could be seen as political or partisan. They don't attend political rallies, don't endorse candidates, don't comment publicly on most political controversies. This restraint exists precisely to protect judicial legitimacy and independence from political pressure. For a justice to walk out of an event where the president is speaking, a dramatic, visible act of protest that cannot be misunderstood, represents a conclusion that normal restraints no longer apply because the threat to judicial independence and constitutional government is too severe. The video footage of the walkout has become a powerful symbol that's being interpreted differently depending on political perspective. Supporters of the justice's action see it as a necessary defense of constitutional principles against a president who has declared himself above the law. Critics see it as inappropriate politicization of the judiciary that violates norms of neutrality. Both interpretations acknowledge the extraordinary nature of what happened. This simply isn't something that occurs in normal political times when normal political norms are being observed. The context of ongoing legal battles between the administration and courts makes Trump's statements particularly significant. The Supreme Court is currently considering Trump v. Slaughter, a case that could determine whether the president has unrestricted authority to fire heads of independent agencies, potentially overturning the Humphreys executor precedent we discussed earlier. Lower courts have been blocking various administration actions on immigration, troop deployments, and agency restructuring. The administration has been found in contempt, in some cases for violating court orders. There's a clear pattern of escalating conflict between the executive branch and the judiciary that provides context for both Trump's rhetoric and the justice's response. Trump's claim that judicial review is meaningless for presidential power directly contradicts the foundational principle established in Marbury v. Madison over 220 years ago. Chief Justice John Marshall's opinion in that case established that it is emphatically the province and duty of the judicial department to say what the law is, including when the executive branch has exceeded its constitutional authority. Every subsequent case involving judicial review of executive action has built on this foundation. For a president to claim judicial review doesn't apply to him is to reject the accumulated constitutional understanding of more than 2 centuries. Legal analysts appearing on various platforms after the walkout have been nearly unanimous in characterizing Trump's statements as dangerous and unprecedented. The phrase direct threat to judicial independence has been used repeatedly. Some have noted that courts evaluating administration legal arguments may now cite Trump's own statements as evidence that the administration is acting in bad faith, claiming legal authority it simultaneously says doesn't really bind it. The rhetoric creates a kind of legal whiplash where administration lawyers argue in court that their actions are lawful, while the president publicly claims legal constraints don't apply to him. The comparison to Chief Justice Roberts' earlier rebuke of Trump's calls for impeaching judges provides useful context. In March 2025, Roberts took the unusual step of issuing a public statement defending judicial independence after Trump called for the impeachment of judges who ruled against his administration. Roberts' statement was measured and institutional, defending the principle of judicial independence without personally attacking Trump. It represented the traditional judicial approach of responding to political pressure with dignified restatement of foundational principles. The walkout represents something different, a conclusion that dignified statements are insufficient and that more dramatic action is necessary. Trump's history of attacking judges and courts provides important background for understanding both his current statements and the judicial response. Throughout his political career, Trump has attacked judges who ruled against him as biased, incompetent, or politically motivated. He's questioned their legitimacy based on their backgrounds or appointment history. He's called for their impeachment or removal. He suggested that rulings against him are illegitimate and shouldn't be followed. The pattern of attacks has escalated over time, and his current claim that the Constitution doesn't apply to him represents the logical endpoint of that escalation, from attacking specific judges to rejecting judicial authority entirely. The implications for pending and future litigation are significant and potentially far-reaching. When the administration argues in court that a particular action is within presidential authority, judges may now point to Trump's public statements claiming he's not bound by constitutional limits as evidence of bad faith. It becomes harder to credit administration lawyers' arguments about legal constraints when the president is simultaneously claiming those constraints are meaningless. This could affect outcomes in cases ranging from immigration enforcement to agency restructuring to emergency powers, any case where the scope of presidential authority is at issue. The constitutional crisis warnings from legal experts reflect genuine concern about what happens when a president claims the authority to ignore constitutional limits. The American system depends on political actors accepting constitutional constraints even when those constraints are inconvenient. When a president claims he's above the law, the system has limited enforcement mechanisms. Courts can issue rulings, but they depend on the executive branch to enforce them. Congress can conduct oversight and potentially impeach, but that requires political will that may be absent in a closely divided legislature. The ultimate check on presidential abuse of power is political accountability through elections, but that assumes voters receive accurate information about what's happening and care enough about constitutional principles to vote accordingly. The walkout itself may face criticism from those who believe judges should maintain strict political neutrality regardless of circumstances. There's a legitimate argument that judges protect their institutional independence best by refusing to engage in political theater of any kind. From this perspective, walking out of an event where the president is speaking, however offensive his statements, crosses a line that judges shouldn't cross because it invites further politicization of the judiciary. This view holds that judges should respond to unconstitutional executive action through their rulings, not through public gestures that can be characterized as partisan. Okay, so let's break this down into the key points that everyone needs to understand, because this walkout and the statements that prompted it represent a genuinely significant moment in the ongoing conflict between Trump and the constitutional system he's supposed to operate within. Point number one, Trump's claim that the Constitution doesn't really apply to him represents an explicit rejection of the foundational principle of limited government that defines American democracy and distinguishes it from authoritarian systems. This isn't normal political rhetoric or standard partisan disagreement about policy. It's a sitting president claiming the authority of a ruler who can do whatever he wants, regardless of legal constraints. The Constitution creates and limits presidential power simultaneously. It establishes the office while constraining what the office holder can do. Claiming the Constitution doesn't apply is claiming unlimited power that the document explicitly denies. Point number two, a Supreme Court justice walking out in protest of presidential statements is essentially unprecedented and signals that at least some members of the judiciary have concluded that normal restraints and responses are inadequate to the current threat. Justices don't do this. They maintain neutrality and restraint precisely to protect judicial legitimacy and independence. For a justice to break with that tradition so dramatically indicates a conclusion that the threat to constitutional government has reached a level requiring extraordinary response. The walkout is itself a form of judicial communication, saying through action what cannot be said in opinions. Point number three, Trump's characterization of judicial review as meaningless contradicts over 220 years of constitutional understanding established in Marbury v. Madison and every subsequent case involving court review of executive action. Judicial review is the mechanism through which courts ensure government action complies with constitutional requirements. Without meaningful judicial review, there's no enforcement mechanism for constitutional limits on any branch of government. Trump's statement isn't a legal argument, it's a rejection of the legal system's authority to evaluate his conduct at all. Point number four, the rhetoric has direct implications for pending litigation because courts may cite Trump's own statements as evidence of bad faith when evaluating administration legal arguments about the scope of presidential authority. When administration lawyers argue in court that particular actions are within constitutional limits, judges can reasonably ask why they should credit those arguments when the president is simultaneously claiming constitutional limits don't apply to him. The disconnect between legal positions in court and presidential rhetoric undermines the administration's credibility across multiple pending cases. Point number five, the escalating conflict between the administration and the judiciary that this moment crystallizes creates conditions for genuine constitutional crisis. If the administration concludes it can simply ignore court rulings it disagrees with, courts have limited enforcement power. They depend on the executive branch to carry out their orders. If a president claims courts have no authority over him and acts accordingly, the constitutional system has few remedies beyond political accountability through Congress or elections. The walkout signals judicial recognition that this crisis point may be approaching. The political implications of this footage are severe and add to the cumulative impression of an administration in conflict with every institution of American government. At 36% approval, Trump has limited political capital to weather crises. The Epstein revelations, the Venezuela controversy, the health concerns, the Republican infighting, the Jack Smith subpoena, each crisis compounds the others. A Supreme Court justice walking out in protest of presidential attacks on the Constitution adds another dramatic visual to a presidency defined by institutional conflict and norm violation. For Republicans heading into 2026, Trump's constitutional claims create awkward positioning that's difficult to defend to swing voters. The party has historically claimed commitment to constitutional principles and limited government. Defending a president who says the Constitution doesn't apply to him contradicts that claimed commitment in ways voters may notice and care about. Candidates in competitive districts will face questions about whether they support Trump's view of unlimited presidential power, and there's no good answer that satisfies both base voters who support Trump unconditionally and swing voters who value constitutional governance. The impeachment implications are significant because Trump's statements provide additional grounds for those arguing he's unfit for office and has violated his oath to preserve, protect, and defend the Constitution. The oath requires the president to uphold constitutional limits on his own power. Publicly claiming those limits don't apply directly contradicts that oath. Whether this rises to the level of impeachable conduct is a political question Congress will have to decide, but Trump's own words provide ammunition for impeachment advocates that didn't exist before. The international implications deserve mention as well. When an American president claims constitutional limits don't apply to him, it sends a message to the world about American commitment to rule of law principles that have defined U.S. foreign policy rhetoric for decades. Allies who share democratic values may question whether America can be trusted to uphold commitments that depend on constitutional constraints. Adversaries gain propaganda ammunition about American hypocrisy. The soft power costs of presidential attacks on constitutional democracy are real, even if difficult to quantify. The judicial independence concerns extend beyond this specific walkout to the broader question of how courts can function when a president claims their authority is meaningless. Judges depend on public acceptance of their legitimacy to have their rulings respected and followed. When a president systematically attacks that legitimacy and claims courts have no power over him, it undermines not just his own compliance, but potentially public respect for judicial authority. Generally, the damage to institutional trust may outlast Trump's presidency, regardless of how current conflicts are resolved. For the justice who walked out, the decision likely reflects calculation that the damage from appearing partisan was less than the damage from appearing to acquiesce to presidential claims of unlimited power. By walking out, the justice made a statement that will be criticized by some as inappropriate political engagement. But by staying and listening silently while a president claimed the Constitution doesn't apply to him, the justice would have appeared to accept or tolerate that claim. Neither option was good. The walkout reflects judgment that active protest was the less bad choice. Looking ahead, this moment will likely be cited in future legal and political contexts as an indicator of how far Trump's constitutional claims have gone and how seriously they were taken by institutional actors. The footage of a Supreme Court justice walking out in protest of presidential attacks on the Constitution becomes part of the historical record of this period, evidence that people inside the system recognized what was happening and responded. Whether that response proved sufficient to defend constitutional government remains to be seen. The fundamental question raised by Trump's statements is what enforcement mechanisms exist when a president claims constitutional limits don't apply. Courts can rule against him, but he claims court authority is meaningless. Congress can conduct oversight, but Republicans have shown limited willingness to constrain Trump. Voters can express disapproval, but that requires waiting for elections. The walkout represents one form of institutional resistance, but whether it and other forms of resistance prove adequate to the challenge remains uncertain. Anyway, that's where things stand with this extraordinary moment that captures in dramatic visual form the conflict between Trump's claims of unlimited power and the constitutional system designed to constrain executive authority. The statements claiming the Constitution doesn't apply, the walkout signaling judicial alarm, the implications for pending litigation, the political damage adding to accumulated crises, and the fundamental questions about constitutional governance when a president rejects constitutional limits. Make sure you're subscribed because the conflict between Trump and the judiciary is likely to intensify as pending cases are decided and as the administration continues pushing the limits of executive authority. Whether courts can effectively constrain a president who claims they have no authority over him, whether Congress will act, whether voters will respond, all of it will unfold over the coming months in ways that will shape American democracy for generations. And if you think the institutional conflict is severe now, just wait until the Supreme Court rules on Trump v. Slaughter and we see whether they're willing to expand or constrain presidential power in this environment. I'll see you in the next one.